It's Entertainment Law Update, episode 188, here at the end of February in 2026. Hello, everybody, and welcome back to another episode of Entertainment Law Update. And from Los Angeles, California, I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
We're so glad to have you here with us. This is our podcast by entertainment lawyers about entertainment law, where each month we round up notable cases and news and information and keep you informed and hopefully a little bit entertained. And we do want to invite your feedback. As always, we welcome that. Feedback, suggestions, and input, you can send it all to us on the email at entertainmentlawupdate.com. You can go to entertainmentlawupdate.com and use our little voice widget, or send us an email, entertainmentlawupdate@gmail.com. Now, Tamara, how are things with you in your home neck of the woods?
Yeah, you know what? Life is great. Been enjoying being at home and kind of doing the hanging out between home and my office in Dallas. I did a CLE actually at SMU Law School last Friday, which was just a load of fun. We talked rapid fire AI in the entertainment world.
Oh, cool.
So it was great. And then I have the upcoming virtual CLE that's going to be part of the mylawcle.com family of programming. That's going to be on this, if you're listening real time, this coming Friday, February 27, 2026, but it should be available to watch after the fact for at least the next upcoming 12 months.
I saw the ads. It looks like a good program, so that should be fun.
And it's not just myself and Jordan Hendricks, who's an associate at the firm I work with at Harper & Bates, but also two other panels on entertainment law topics that I think would be really worth checking out.
That's fantastic. Well, here on the West Coast, I was just telling you before we started recording, went to the theater last night, saw the Broadway show 6, which is a fantastic piece of entertainment and well worth the investment. If you haven't had the opportunity, I highly recommend it. And I don't know, we're getting ready for a high school graduation here in a month or two, and it's pretty crazy.
I was looking back to see, kind of counting our years of the podcast, and I realized this is triggered by your child's age as well.
Yeah, Nate was, my oldest Nate was, about 9 months old when we first started recording the show. I remember him crawling around at my feet while we were recording.
That's right. So I didn't know that part, but when I think when I got in your holiday greetings, I realized that he was graduating and you guys were doing college visits, and I was like, oh my gosh, he was just a brand new baby when we started.
Yeah, it's really something. So our show is ready to graduate college or graduate high school and off to college. He and his mom are going to go visit my alma mater, which is one of his preferred schools, the University of Oregon, leaving tomorrow morning. So
go Ducks.
It's exciting. Yeah, go Ducks. Quack attack. And so life is moving fast around here, and we're having a good time. But let's get into our stories now. We have a bunch of good, interesting topics, some of which a little off the beaten path for Entertainment Law Update, but let's just jump right in and get started.
Well, we will. And this first one is on our standard path, music and AI. That's our path. So breaking as of just January, February, the complaint filed January 28th, a litany of music publishers, including Universal Music Group, Concord, Sparrow Song, and Worship Together Music, have joined together and sued Anthropic in the Northern District of California, and they're claiming copyright infringement due to the copious amounts of piracy, accusing Anthropic of retrieving music through BitTorrent and then using that to train its AI. How did they figure out that was going on? Well, because of the disclosures in the Bartz v. Anthropic case that wrapped up and settled in 2025. Over 20,000 works that belong to the plaintiffs have been identified and referenced in the complaint. This is a new filing, but for those of us, I think both of us included, that might have been a little unsatisfied with the settlement in Bartz v. Anthropic, this upcoming sequel might get us some resolution that we're happy with. I don't know, but we'll be watching it. We normally don't talk about things recently filed, but this one's important.
It is, and
Keep an eye on.
it's encouraging to know that we'll have something to talk about for months, if not years to come, with the various cases.
Yeah, and it's also is it encouraging, interesting? It came out of disclosures in the other lawsuit that they realized Anthropic's parent company was downloading songbooks.
Yeah.
That had their songs, their music publishing, that the songs in it that the music publishers owned.
Yeah, and Anthropic is in the crosshairs. A bunch of other cases as well, and the other sort of breaking news this week has been the AI generated film. What's it called?
Yes,
something dance. It's ByteDance is the parent company of
ByteDance. We talked about that Friday at the CLE. I was on the panel with, and it was great. My good friend and colleague Lisa Normand, who's a film and TV producer and film and TV lawyer here in Dallas. We talked about it Thursday night at the speakers dinner, and I'm like, I don't know what you're talking about. I'm like, I'm going to be surprised with the audience. I will watch the clip real time.
The Tom Cruise
of the fight sequence with Tom Cruise and
Brad Pitt.
AI generated Tom Cruise and Brad Pitt. So
it's pretty wild what the technology is capable of these days, and the law, as always, is a little slow to catch up on things. So something else.
And I think what I learned from that was that the folks who have sent the cease and desist letters, takedown letters, were the various studios and production companies, but there was no mention
of the name, image, likeness stuff.
Of the name, image, likeness.
Yeah.
So anyway, that's an interesting story. If you've had the TV on, you've probably
and we'll be talking about that more too.
Yeah.
Another area that we don't often cover is cases that have come up in other countries. And here we have sort of an interesting one coming out of the Supreme Court of South Korea. The case is Starship Entertainment, which is, I guess, an agency or something. The case is this. Back in October 21st through June, of 2021 through June of 2023, a woman identified as Park, who operates a YouTube channel called Sojang, published 23 different defamatory videos targeting 7 different public figures, one of whom was this person, Jang-won Young of IVE. These videos allegedly fabricated scandals and made personal accusations that were designed to provoke public hostility and generate views. So basically takedown videos, trash talking people. Park was convicted of defamation and insult under South Korea's Information and Communications Network Act. On January 29th of this year, the Supreme Court of South Korea did issue a final ruling in the case involving Starship Entertainment and the operator of that channel. The court upheld the lower court's ruling, finalizing a sentence, 2 years in prison, that was suspended for 3 years, along with a forfeiture of 210 million won, which is about $146,000 US, and also 120 hours of community service. So defamation is a crime, I guess, in South Korea. Central issue in the case was whether framing claims as speculation or allegations is enough to shield a content creator from liability for this kind of a thing. And the court said no. It said that context is more important and it controls even when there are disclaimers. If the overall presentation leads the audience to perceive them as factual statements, and if they are false and harmful, then those constitute unlawful dissemination of false information, even when there's that tentative or allegation kind of language. And the court also looked at it and emphasized that when the digital content is monetized, even monetized digital content doesn't receive any special immunity. Public figures are entitled to protection of their honor and reputation. It's a very Asian concept, I think. Just like private citizens are. And the scale and duration of the conduct, 23 videos in the course of about 2 years, supported a finding of systematic malicious behavior, not just isolated commentary that got something wrong. So this is a significant ruling because it closes a loophole often used by online content creators that hide behind the ambiguity while intentionally driving reputational harm for profit. And the decision signals a stricter stance by the courts in South Korea toward this kind of digital harassment and so-called cyber wrecker content channels that monetize these rumors and scandals. So sensationalism is fine as long as it's accurate sensationalism,
Okay.
I guess. So in short, the South Korean Supreme Court affirmed that the speculative framing isn't enough to shield deliberate falsehoods, and this can carry serious criminal consequences. Now, here in the U.S., of course, we have a very different body of case law, and the First Amendment weighs heavily in this arena. The case of Gertz versus Robert Welch says that a public figure is an individual who's assumed roles of special prominence in the affairs of a society or thrust themselves into the forefront of particular public controversies to influence resolution of the issues involved. Public figures are people who've achieved pervasive fame or notoriety and so on. And whether a party is a public figure is a question of law for the court. And public figures that want to recover for injury to reputation in these kinds of cases have to show actual malice by the defendant. And that obviously is clear and convincing evidence that the falsehood was made with knowledge of its falsity or some reckless disregard. So would that have worked in the South Korean case? Probably. 23 takedown videos over the course of 2 years. Pretty clear that the creators of those videos knew that what was being disseminated wasn't accurate. It was all part of that sensationalism. So just an interesting look at how other countries handle these things.
Yeah.
And maybe even the risk
And
to
maybe
Americans.
right. But, and sure. And so let's say you're a very popular content creator and your actions in the US would not rise to that standard. But you also tell everybody where you're traveling.
Right.
On your Instagram and your TikTok.
Yeah.
So you've said something about some other public figure in another country. I don't know.
Yeah, I mean, this is something
what could happen.
I think that American, content creators all around the world have to be cognizant of the fact that defamation law sort of operates under the home country of the recipient, not the victim of the defamatory remark, the subject of the statement. And so if you are then subject to the jurisdiction of courts in that country, this might be something to watch out for, especially if you're doing takedowns of public figures in South Korea where there's a criminal penalty for this kind of thing. So be thoughtful and careful to the creators out there.
Yeah.
And pretty interesting. Pretty interesting. Well, we have another case that takes us back, really. It's sort of a flashback to early internet law back in the days of the Prodigy case, for those of us that remember that. The case is called McGucken versus Shutterstock. It was decided in February 10th, so just a couple of weeks ago, and it raises a really sort of deceptively simple question about when does an online platform stop being a passive host and start becoming legally responsible for the content that it distributes. And if that sounds familiar, it's because it echoes the kind of tension that was really going on 30 years ago when Section 230 of the Communications Decency Act was being discussed and eventually became law. You might remember there was a case called Cubby versus CompuServe involving some defamatory statements made by users on the CompuServe service. And then and that one went in favor of the service because they were merely a conduit for the messaging and not editorializing. And then we have the Prodigy case, which we'll talk about in a second. Anyway, in this case, the plaintiff is Elliot McGucken, a professional photographer who had images of his appearing on Shutterstock without his authorization. Over the course of a few years, from 2018 to 2022, a number of third-party contributors uploaded hundreds of McGucken's photos to Shutterstock's platform, and they were displayed in the searchable catalog. Customers licensed them. Shutterstock collected fees for those licenses, revenue shared with those contributors, not McGucken. Once they received DMCA takedown notices, and they did receive them, it removed the images and terminated the offending accounts. But then McGucken decided to sue anyway and alleged copyright infringement violations of the DMCA, including removal or alteration of copyright management information, CMI. So the district court granted a summary judgment entirely in Shutterstock's favor. But on appeal, the Second Circuit took a different approach and sort of split things down the middle. So on the question of metadata, the removal of that copyright management information, the arguments that Shutterstock improperly handled that data, metadata embedded in the image files. So Shutterstock required that contributors enter metadata fields. They processed the images with standard ingestion systems and often replaced or reformatted the embedded information in the images with its own platform data. So preview images carried watermarks. Those were removed once a license was purchased. You know, we've all gone on these image sites and figured out how that was. So some of the metadata was actually stripped or altered during this automated process. But the Second Circuit had an earlier case called Mango versus BuzzFeed, where it said that liability for this kind of thing requires a scienter requirement, essentially, two mental states. First, that the removal or alteration of the information was intentional, and secondly, that the knowledge that doing that removal would facilitate infringement. So the court found there was no evidence that Shutterstock intentionally removed attribution to hide infringement. There was no evidence that it substituted its own authorship, no proof that it knew the uploads were unauthorized when they were processed. So on those CMI claims, Shutterstock wins, summary judgment was affirmed. Operational processing isn't the same as having a deceptive intent. But on the DMCA safe harbor question, that's where the real action in this case is. Section 512C of the Copyright Act allows for this safe harbor. To qualify, a platform has to show that the infringing material was stored at the direction of users, that the platform lacked specific knowledge of the infringement, that it responded, accordingly to the takedown notices, and that it didn't receive a direct financial benefit while exercising control over the activity. And the court said Shutterstock met those requirements. The district court said that. Now, the Second Circuit wasn't so sure, and it basically a big maybe. So the court leaned on earlier precedent, Viacom versus YouTube being the most obvious one. That established several core principles. First, that the safe harbor is an affirmative defense in copyright cases, that general awareness of the infringement isn't enough. Remember, we used to talk about red flag knowledge.
Right.
And platforms don't lose protection merely because they have the ability to remove content. So the knowledge has to actually be tied to specific infringing works. And that also follows a later case, Capitol Records versus Vimeo. So far.
Right, and that was just last year,
Yeah.
Capitol Records. So 2025, a really recent decision.
Yeah. So far, this standard platform protection kind of doctrine, right? But the court looked at something that Viacom had left unresolved. What happens when the platform exercises substantial influence over the content that it distributes? This is where things get interesting. Is Shutterstock a host, or are they more like a curator or an editor? The appellate court pointed to evidence suggesting that Shutterstock might be doing more than just storing user uploads. There was evidence of human screening before the content was accepted. There was rejection of certain submissions that didn't live up to certain standards, organization into a structured licensing catalog, the standardization and categorization of that metadata we talked about, and marketing and monetization of specific work. So Shutterstock wasn't just hosting it, it was running a curated commercial marketplace, at least in the eyes of the Second Circuit here. So that raises this factual question. Are the images on the platform there because they were uploaded by users, or because Shutterstock selected and commercialized them? And if it's the latter, maybe the safe harbor doesn't apply. That's where the case feels like this internet deja vu I was talking about. Back in the 90s, the case of Stratton Oakmont versus Prodigy, where the online service tried to moderate user content to keep things clean and family friendly and so on. But that editorial involvement caused a court, this is pre-Section 230, caused a court to treat Prodigy like a publisher, which exposed it to liability. So Congress responds back then by passing Section 230 to avoid discouraging that kind of moderation. And here we have McGucken that doesn't involve a Section 230 claim. It's a copyright law case, not defamation. But the same policy tension is at work here. The more the platform curates and shapes the content, the harder it is for it to claim neutrality. So the Second Court draws the distinction, looking at automated technical functions, things like formatting, tagging, transcoding. Those things remain protected. And the cases like UMG versus Shelter Capital and Perfect 10 versus what was the
Google.
Well, Perfect 10 also was another one, CC Bill, I think. But yeah, all those Perfect 10 thumbnail cases. But editorial gatekeeping might be different, says the court. The court even referenced, this is the Second Circuit, even referenced the Ninth Circuit's case in Maverick versus LiveJournal, where active moderation raised questions about whether or not the platform's involvement was truly passive or not. Now, the Second Circuit stopped short of adopting that rule outright, but it said that the comparison was relevant enough for a jury to have a look at this. So, summary judgment was improper, and the court looked at two statutory requirements that become fact questions for trial. First, were the images stored at the direction of a user, and did Shutterstock have the right and ability to control the infringing activity? This evidence of selective acceptance and structured licensing, presentation, and direct revenue all could allow a jury to find that there was meaningful control over that second factor. So the court vacated the summary judgment on the copyright infringement and sent it back for further proceedings. So Shutterstock might qualify for the safe harbor, but...
And maybe we'll get more clarification on, at least in that circuit, what is qualifying.
I mean,
I think it's how much content control and moderation is too much.
Yeah. I mean, the lesson seems to be the more editorial judgment you exercise, the harder it is to claim you're just a messenger.
Well, and as we were talking before we came on, it just made me, I went directly back to Prince and the Dancing Baby video, which is based on a fair use argument. And is part of where we, red flag, I think, and while it's the YouTube case, but part of that case in the Dancing Baby was, what I remember came out of that was that YouTube was supposed to develop a policy where a real person was needing to make some decisions and review content. Now, I don't know where that landed because that's been 10 years ago as well.
I don't remember it as a real person, but they did develop the Content ID system that is the technological
that came out of that. And maybe at the conversation or the court was saying it might require a real person. But now it doesn't. There are no real persons. It's AI.
Right.
There are no more people. This is virtual Tamara and Gordon. Don't
Skynet is here.
We're gonna fight like on Skydance. So is it the prompts you give AI on how it screens the new content that gets uploaded to the platform?
This case seems to signal that it might be possible to overdo it and expose yourself to liability because of the screening.
Is this a you can't win for losing
right
proposition here? But I do wonder if, so my understanding from the facts is it wasn't just one alleged bad actor uploading McGucken's content. It was lots.
Yeah.
So you would think there would be something in their system that would trigger all these pictures look alike. We're getting multiple metadata similarities.
Yeah. Well,
there has to be a way for that to overlap that should have triggered some assessment.
And what's interesting is it sounds like their system wasn't looking at the original metadata of the upload, but only at the information that the users were inputting. And so it may not have been able to, may not have been set up in such a way that it could detect that original metadata was similar, coming from the same cameras and locations and things like that. But there's a lot of information in just when you take a digital photograph, there's a lot of information embedded in that photo that most of us users never see, but it's there. It's called EXIF data, EXIF. I don't know what that stands for, but so if the system had looked at that and been able to see duplicates or multiples of things showing up, then that, well, maybe that would have spared them. It's sort of a damned if you do, damned if you don't scenario we've got going here.
Right.
So anyway.
I don't know.
Yeah.
It'll be interesting to see.
Yeah. Let's talk about SoundExchange.
Yeah. So in 2024, and we probably didn't talk about this, but anyway, SoundExchange announced that they were developing a global artificial intelligence registry for sound recordings and their creators and the rights owners. The database is being designed as a, quote, authoritative sound recording data to enable rights owners more control over the use of their recordings in AI models. Okay, that all sounds pretty good. I recently received an email from SoundExchange on behalf of various rights holders asking, or really just notifying them, you need to log in and make an election regarding a designation in this AI registry database indicating the use or non-use of their sound recording copyrights in AI training. And I was like, what?
You mean indicating whether you're okay with it or not?
Yeah.
Okay.
And so, quote, let us know your interest in participating in this registry that will inform companies the following for each of your recordings. Are your rights totally reserved? Do you need to contact the rights holders? Or you've not indicated? So you've reserved your rights. You can't use them for AI training. Maybe you might reserve your rights. Give me a call. Or we haven't responded to this question. And then if they do make a one of these choices, they need to sign a declaration saying they've made the choice. Now, this is the place where I'm like, okay, maybe this is why they're using it. Because the European Union has passed a law that may permit certain uses of copyrighted content for, quote, text and data mining without a license, unless a rights holder has reserved its rights with respect to such use. And again, this is directly from the email. Or in other words, opts out of the text and data mining exception.
That seems...
So while in the U.S., I don't think I should have to reserve any right because I haven't granted you the right.
Yeah. Yeah, I mean, it's that, first of all, that EU thing seems kind of contrary to the principles of copyright law, even at the international level. But certainly here in the U.S., an opt-in system an opt-out system seems to be, well, wait a minute, you're taking rights that belong to a copyright holder and saying, well, unless they opt out. So
yeah, I have not taken an opportunity to speak with someone at SoundExchange just to kind of understand more. I just, red flags flew up when I read that email a few weeks ago and sent it to you and said, we should talk about this.
Now, SoundExchange doesn't have any operations overseas, does it? I mean, it's mainly
so
an American entity.
You can elect for them to have the pass-through monies collect on your behalf.
I see. So
you could set them as your collection agency for digital public performances of your sound recordings.
Okay, and that's
internationally.
Yeah, and that's just sort of.
So again, this only applies to the digital public performance of sound recordings, which we have that right in the U.S. and most, I think, all other non-third world countries. But the U.S. is the only The U.S. is in the same category with third world countries as in we do not have public performance for terrestrial radio. So that's kind of the distinction. Those international companies are collecting for terrestrial and digital. I don't know. I just thought this was something we needed to point out for everybody to take a look at.
Well, it seems like clients. A move by a private or semi-private organization to sort of head in the direction of the EU approach rather than staying with the status quo in the U.S. and I don't know. I have thoughts about why that's happening and how that's happening, and the influence of companies like Spotify, and also we have a story we'll talk about in a little bit about the restatements and how those have been arguably steered. So
we've talked about those in the past. Yeah.
So, all right. Well, that's interesting. We'll keep an eye on it. But anyway, so if you're a rights holder, you want to go on to SoundExchange and enter your account and make this election. It sounds like, to opt out of AI using your stuff.
Right. You need to go in and make the decision as to what selection you'd like to make.
I mean, it sounds like if it's just been the election hasn't been made, it's not changing your rights as a copyright holder in any way.
That's my understanding.
Yeah. Okay. But still, it makes sense to just be affirmative about it and say, this is how I want things done.
Yeah, and then can I put an asterisk, but notwithstanding the foregoing, this really doesn't.
Right.
You really don't have the right to give me the right. Yeah.
Right. Well, the music copyright arena has been a hotbed of discussion and activity in the last few weeks because the Olympics have just happened. By the way, congratulations to the American women's hockey team and all the winners of all the medals. But it was interesting. Statistically, the women outpaced the men in American gold medals. I think it was 2-1.
That is. But I watched portions of both the gold medal rounds for the women and the men 46 years ago. And the fact that game was the men's gold medal game was played on the exact day.
Mm-hmm.
Did you know that?
No.
Which happened to also be a Sunday.
Oh, interesting.
I distinctly remember I could not get home from church fast enough to watch that hockey game.
Yeah.
And, you think, how would I have really understood what the importance was? Because, I mean, was I even alive in 46 years ago? But anyway, I have to admit, I was late for church this Sunday.
Oh, because you were watching the game. Okay.
Because I was watching the game.
I did not get to watch as much as I wanted to, but yeah. Anyway. Let's talk about the music stuff, though, because this is
this is great.
There was a whole bunch of licensing issues with music, but the one that sort of took prominence in public imagination was, I'm going to get his name a little bit wrong, but Tomás Lawrence Guarino Sabate had a skating routine utilizing music from the Despicable Me Minion films. And he hadn't originally cleared the music, but eventually was able to obtain the rights and clearance to use the music. But it raises the question of, well, first of all, up until 2014, the Olympics required public domain music for the routines. So in 2014, they changed it. They're trying to get a little more public interest and attention from young people and whatnot. And so skaters are using pop music now. And this opens up the questions about, well, what clearances are really required in order to perform in the Olympics? And you correctly pointed out that public performance rights are very different in the U.S. than in other countries. And certainly there's more to it than a public performance when the events are being televised. So first off, public performance only applies to the composition side under U.S. law. But in many other countries, there's a public performance right in the recording as well. So if you're going to be performing a piece of music in other countries, you need the full performance right for everything, similar to the way we would license for broadcast.
Right. And the nice thing on the public performance aspect, the broadcaster is going to get that.
Mm-hmm.
So I don't think we're going to need to have, individual skaters going out and getting clearance related to public performance, because NBC Universal has a blanket public performance license. Again, I'm just talking about U.S. rights. That's going to cover that. The bigger issue I think the skaters were facing was they had either not gotten a synchronization license for the musical composition, and the equivalent to that for that sound recording is the master use license. And I'm wondering if they got an arrangement license, which was most of the performance tracks are an arrangement of more than one musical score.
Mm-hmm.
So But yeah, how do you get to the Olympics and you haven't cleared the music? That's the question I have, especially for anyone in the US.
Yeah.
Maybe for some of these foreign athletes, it just has not been quite the issue until you're on the Olympic stage.
I want to go back to the public performance thing, because there is also the public performance of the live presentation in the venue, which would typically be covered by some kind of a PRO license by the venue. But I believe that the Olympics actually doesn't want to handle that at all. So they're saying individual skaters need to get that right as well under the Olympics.
Interesting, rules. Because they play music in between. I mean, there's other music happening at events at the Olympics.
Yeah. And I don't claim to be an expert on this. It'd be interesting to talk to somebody.
Yeah, I think there's questions. Right. We don't know all the answers to those questions, but we know it was definitely in the news that people were changing their routines because they didn't have the rights to the songs and sound recordings.
So, the scope of these licenses nowadays, certainly for an Olympics event, needs to be sort of a worldwide license so that there's no carve-outs required and that the broadcasts can happen and so on. Skaters are going to want these licenses to last forever, in perpetuity, even though the performances are going to happen in a specific window of time and then probably be archival after that, after a couple of years. But you never know. I mean, someone may want to use a clip for a news or documentary or something like that later, many years later. So other issues that came up this year in this licensing space was U.S. figure skater Amber Glenn used Seb McKinnon's song "The Return" without permission, and then had to work things out after the fact. A Russian skater, Peter Gumenik, I think it is, who's participating as a neutral athlete in the games. Interesting. He had to change his music at the last minute because he hadn't been able to get clearances. A Canadian ice dance team had to change their routine after they couldn't clear a Prince song. Belgian skater Leona Hendricks switched songs after the Celine Dion song she had originally chosen was presenting challenges and so on. So all of this is... Go ahead.
So here's my question, only because 46 years ago, I probably watched every Saturday ice skating event that was on TV. So, you saw them skate many times before the Olympics, or at least a few weekends before the Olympics. Yeah. So it wasn't like they were changing music.
Right.
So I'm going, well, why didn't they just clear it for the whole season? Or is it maybe they weren't? I don't know. That's what I just don't understand, the aspect of it, because in a perfect world, you'd contact the publisher, but we also know the publishers don't like to respond.
Yeah,
timely. And so maybe that was it. Right. They're just like, until you tell us you're going to be in the televised broadcast, we're not talking to you. I don't know. But you would think they would have a system designed specifically for clearing music for the Olympics.
Well, you would think, but the truth is there's a whole community of Broadway theater and things like that uses grand rights. And I think this is sort of akin to a grand rights. It's not just a small performing right. When there's a choreographed skate happening to it. And so, they want to extract whatever price they can get depending on the popularity of the music and the size of the event and so on. So it may also be that the licensing, the rights owners don't want to have a what's the word I'm looking for, a standardized method for doing this.
Well, maybe that's where that's landing about the Olympic, the IOC pushing back on the public performance license, because you can only do those. And again, I'm going to use this under if this was what's happening in the U.S. That music, live music, and performed publicly is going to be the ASCAP, BMI, CSAC, grand music rights.
Unless it's grand rights.
Unless it's grand rights, because this is the small right, and grand rights being when it's combined theatrically. So maybe that's it. You've got to clear the grand rights.
I suspect that's
and
what's
it's
going on.
And it's not one-stop shopping.
Yeah. And there is a licensing group, an agency of some sort called Click and Clear, and others like it, that skaters could use to get the licenses they need. But it's hard. I mean, if you're an ice skater, well, if there's a team and a machine working behind the scene for anybody who's on a skating team or something like that, you'd think they'd have this sort of figured out, or at least a checklist approach to things. But apparently they're not real well equipped to do it. So when something big like the Olympics comes up, it becomes a scramble. It may be also that the rights holders don't care so much about the little regional competitions and things like that. But international competition isn't just the Olympics. That's something to remember. So,
right.
Be interesting.
Anyway, it's always fun to kind of see it play out in the in the wild.
Yeah.
And other people are talking about it besides just us.
Right. It'll be interesting to see what happens in the Summer Olympics in 2 years and next time around. And maybe an organization like Click and Clear will be able to expand its influence, or maybe the music industry can establish some protocols for making this a little easier. Maybe the IOC can step in and what's the word I'm looking for? Sort of try to exert some influence to make it a more accessible process.
An easier process to navigate. I also noticed that during the hockey game, there was an organist playing.
Mm-hmm.
And so maybe they didn't have piped in music. I don't know. But maybe somebody was at the game or physically there, or noticed something I didn't notice.
Yeah. Well, I do think that interstitial music is different from the soundtrack for the performance.
Right, because I think it is a true small right public performance when we're hearing that.
So interesting, fun to sort of dismantle that and figure it out, and maybe there'll be something for us in it to do some of that licensing in the future.
Yeah, that would be awesome, because I think you're right. I think it's triggering a grand right.
Yeah,
and that's what the difficulty is. So.
Well, interesting. And it'll be interesting to see how AI plays into this in the future. Are people using AI music for their skating routines to avoid having to license?
Yeah, but what was it trained on?
Well,
anyway.
Good. Yes, exactly right. Exactly right. Well, speaking of AI, let's transition.
Oh, my goodness.
You heard about this case? This lawyer who, I don't have a citation for the case in front of me.
February 2026. Yeah. So it was a
Flycatcher versus
decision.
Affable Avenue. And it's in the, well, we'll find out. So this New York federal judge, New York. So it's the Southern District of New York. Second Circuit. Yeah. So the federal judge took the rare step of terminating sanctions over a lawyer's repeated misuse of AI in drafting and submitting filings. The judge, Catherine Polk-Failla, was concerned with the origin of the brief's misstatements, as well as the attorney's delay in responding when confronted about this. So issued an order to show cause. That attorney, Stephen Feldman, responded with another submission that also appeared to have been created by a generative AI, and that itself contained a false citation that, in looking at the PACER listings and so on, it looks like the opposing counsel flagged it for the court and said, hey, here's more of this, Your Honor, what gives? And then there was another brief in support of his party's motion to dismiss, which also included false citations. And then at the hearing, Feldman was not able to respond satisfactorily or directly to the court's questioning about his submissions. So the concerns that denoted the use of AI were, in the first motion to dismiss, 13 cases at least cited did not exist. 8 did exist, but did not actually contain the quotes that were attributed to them. So it's not enough just to verify that the case exists, but you better verify that the citation is accurate.
That's right.
It actually says what you're saying it says. The brief began with a 3-page introduction, followed by separate and duplicative preliminary statement. Pretty big signal that this is not human generated. In the order to show cause response, the writing was conspicuously florid. And returned.
Okay, don't get too florid
Right,
or
exactly.
fluffy in your writing.
Featured a quote from
Lawyers don't do that.
right, quoting Ray Bradbury's Fahrenheit 451, which, as far as I know, isn't valid case law for anything. Metaphors comparing legal advocacy to gardening and the leaving of indelible marks upon the clay. I mean, these kinds of quotes, florid is the right word. The attorney's response to that order to show cause, he took quotes from cases that were actually direct quotes from articles recapping analysis of those cases. And in a separate letter to the plaintiff after they rejected Feldman's motion to withdraw, the style was very different and described by the court as being riddled with mistakes and broken prose. One was 9 lines long, but comprised just a single run-on sentence. Wow. So the legal term representing the other defendant, co-defendant, noticed this, and rather than correcting the submissions as the fellow co-counsel asked, Feldman offered a big excuse and explained that he couldn't verify certain citations because he no longer had access to legal research databases like Westlaw. If you're a litigator and you don't have Westlaw, what's going on?
Yeah, or go to the law library. I mean,
it's not like the information is concealed, books. Right?
That's right.
So despite urgings from that other lawyer, lots of warnings from the court, an order to appear and show cause, and lots of apologies, Feldman continued submitting these briefs with the non-existent cases. So the court estimated that about a fourth of the case citations were non-existent hallucinations. Feldman corrected that approximate number was not accurate or exact. So the judge's later order clarified, saying, quote, "The court recognizes the mathematical truism that 14 out of 60 is less than 1/4, but the fundamental point remains first that it is 14 fake cases too many."
Yep.
So don't quibble about the semantics when the primary principle is what's at stake here. So the judge noted that the court doesn't oppose using AI to assist in legal research, but that it couldn't ignore the knowing decision to use the flawed methods of legal research and site checking, couldn't ignore the inexplicable refusal to verify submissions before filing them with the court, and couldn't ignore the unwillingness to come clean once these issues were revealed to the court. So February 5th, the judge dismisses the case. Extraordinary sanctions were warranted after Feldman's repeated failure to exercise professional judgment and responsibility and bad faith conduct. So I guess Mr. Feldman's malpractice carrier is going to be paying attention now.
If he has one,
well,
right, who knows?
Right.
But I guess just other practice pointers. Obviously, if you're doing litigation, subscribe to LexisNexis or Westlaw
and
or one of those and use it. But other resources that you could probably start with and then verify.
Mm-hmm.
Google Scholar.
Yeah.
Again, I would still verify that against information to make sure it's correct. But the Texas bar, at least in relationship to Texas case law and maybe Fifth Circuit case law, we have free access as a bar member.
Yeah. That's not the case in California. We don't have free access to anything, legal research tools.
Well, yeah. So we have free case access to information.
Yeah.
So check with the state bar if cost is an issue.
Well, but the cases are public record anyway, so you should be able to find them. And I think it's fine to use the AI. The court even says it's fine to use AI to do a preliminary draft and to assemble everything. But then you got to go through and actually verify that each case that's cited not only exists, but stands for the proposition that it's actually being cited for. And if you don't have it, that case has to come out of so.
Right.
I mean, Mr. Feldman, I don't know what's going on with you, but that sounds just like plain old bad lawyering.
We don't know what's happening in his world. But now we know how to be better.
We know we have a professional responsibility, and this clearly wasn't in accord with that responsibility.
Right.
So here we are a few years in since the Copyright Claims Board was founded. That's the small claims operation for copyright cases. And the Copyright Office has finally released a long-awaited study of how it's performing, how the CCB is performing. The Case Act, which formed the entity, also requires the Copyright Office to periodically report to Congress. And, this is addressing that problem we used to talk about a lot about. Sometimes it's a matter of how much justice can you afford. And this is designed to sort of address that concern. So the board launched in June of 2022 as a voluntary streamlined tribunal for cases up to $30,000 per case. And now we have some data to show that since the CCB was formed in June of 2022 through March of last year, there were 1,222 claims filed. About 53% of those were the standard up to $30,000 damage claims, and the remainder, about 47%, were smaller, like up to $5,000. So that's interesting, close to half and half. Okay, of those 1,222 cases, the snapshots. There were 826 claims filed up till 2024, April of 2024, and another 1,000 or over 1,000 by the end of that year, and a few hundred more in early 2025. So certainly shows that there's some demand for this low-cost enforcement mechanism. Of the cases, only about 35 cases, so about 3%, had actually gotten a final determination on the merits as of March of 2025. Most of those cases, like in regular big boy court, I guess you could say, the vast majority were resolved either through procedural dismissals or settlements or voluntary withdrawals, those kinds of things. Not necessarily a failure. It mirrors how other small claims courts and mediation forums typically function. And it's voluntary participation. So opt-out rates, the report says the opt-out rates have been lower than first expected, that more of them have actually gone through the CCB than the critics were predicting at the time. So system seems to have legitimacy for both sides of the cases. So bottom line, the Copyright Office says the CCB is successful overall, helps resolve disputes that wouldn't receive much attention in the regular federal courts, facilitates settlements, increases confidence in copyright enforcement, and provides meaningful access to remedies for individual creators and small businesses. So there were some improvements recommended as well. A few tweaks, procedural stuff like simplifying compliance review, streamlining service of process, that would be good, shortening some of the timelines, and reducing sort of the administrative struggles and friction. So system works, but it needs a little tweaking. Good to know. So
and then one of the other things I think is interesting here that is, should the court be expanded to take on mediation and non-binding ADR services?
Yeah, interesting question.
And
go ahead.
And a question has been posed to me is, and perhaps it would be an expanding of the court's jurisdiction, and it probably cannot be expanded as to how the court is set up. Well, I don't think you can't pick that court as your choice of venue, your choice of law, your choice of jurisdiction, I guess, where we're gonna in a contract case,
right,
that even though it's small claims for copyright, it's small claims for copyright infringement,
right,
not copyright breach of contract,
breaches of licensing deals and things. Yeah. But I think the takeaway here is for photographers and podcasters, filmmakers, individual creators, and so on. This represents a sort of part of the system that really was never available before. It's a practical enforcement mechanism for these smaller cases, the kinds of things that would have been traditionally viewed as too small to involve lawyers in lawsuits. So it's designed to close a gap, and it seems to be doing that. So that's good news. Good news.
Yeah, and I was trying to find if I don't think there's a chart in this summary or in the actual materials that the Copyright Office released as to what was the subject matter of the 35 cases or so that were actually fully resolved. And maybe that's on their website. I don't know. I
seem to think we had data like that maybe a year ago or in the fall.
I think so. I think they have that data. Maybe you can kind of poke around on the website, or I can poke around on the website and see. Have you used it yet?
I have not had occasion to be involved in, but I'm not a litigation guy anyway. So
I'm not a litigation person either. But I've had these conversations with lots of different people about the procedures, and it's small claims. You don't have to have an attorney to represent you.
I think that's part of the reason such a large percentage of them have been dismissed or handled without going through the whole system, is because there haven't been attorneys involved. So the leverage is strange, especially when one of the parties is an entity that has legal teams and things like that, and the other is an individual creator.
And over the years since it's been going on, I've gone in and read filings and different things, and a lot of times the individuals just may not know how to fulfill the requirements of submitting the evidence, or
which I think is probably the case in typical small claims cases around the country as well. So you still have to understand the system and the procedure, and while the clerks of court may or may not be much help, there's it's really, you got to be able to do it yourself to make it work.
Right.
Well, so you've got your CLE course on Friday. What's the URL for folks to visit to sign up?
mylawcle.com.
mylawcle.com. We'll get that into the show notes.
And I don't know if you search my name, I can't remember if it'll come up, but like if you're logging on as this goes live between now and Friday, as soon as you go on the website, you're going to see us, as live events happening. But you can just search for entertainment law in the CLE subject line, and it'll come up.
And these are recorded, so it's not just for Friday, but anybody who wants to access that CLE credit can do so.
That's right. We're recording on Friday, and check it out. It looks like a good way to get some CLE or get all your CLE for the year.
Yeah. Well, as always, I want to say a big thank you to our loyal listeners for spending this time together with us. And again, invite your feedback and commentary. We hope you can leave it for us using our voice widget on the website. I wish more people would use the widget, because it's nice to have something to play in the show. But you could also just send us so that's entertainmentlawupdate.com. That's our website. Or send us an email, entertainmentlawupdate@gmail.com. And we look forward to hearing from you listeners, and let us know what you think. If we're doing well, great. If we're missing the mark, what's the same? If you have positive feedback for it, leave it for us. And if not, keep your mouth shut. But no, actually.
No, we want to hear from you one way or the other. Yeah. Because if we got it wrong, we'd like to know.
Yeah. Well, Tamara, thank you again, as always, for doing this. And how can listeners get a hold of you?
Yeah, folks can find me at harperbates.com. That's my firm's website. On most social media at Tamara Bennett, TaMeraBennett, and also at createprotect.com.
And I'm Gordon Firemark, located in Los Angeles. The website is firemark.com. My email address, gfiremark@firemark.com. And on most social media, gfiremark is the handle. Easy to find me. Let's give a shout out to our team. It's a dwindling team, so there's an important invitation as well. But we have John Janicek, Charles Thorne, and Alexis Allen helping us out with the show. And we appreciate all that help, but we could use more of it. So if you're interested in joining the fun, become a part of our team of contributors. It's like a little family. Reach out to us, entertainmentlawupdate@gmail.com. Just let me know you're interested in getting involved, and we'll be happy to talk with you about it. So that's a wrap for this episode. Thank you for being here with us. Whoops. Go through the buttons here. All right, here we go. Have a great one. Thank you. That's Showbiz.